Good evening and welcome. It's now 6 o'clock. I'm handing over to Dr. Mark Heeman. Dr. Heeman, over to you.
Good evening, colleagues, and thank you very much for joining us this evening. This is the second webinar in a 4-webinar series covering the medico-legal environment and different aspects of it. Last week we dealt with regulation and who governs us. Today we talk a little bit about medical negligence, and there are 2 more webinars coming which include criminalization of adverse medical events, as well as further understanding to be able to give us perspective in how we fit into this whole medico-legal environment. Tonight I'm very proud to be able to introduce you to Mr. John Sainer, Advocate John Sainer. Just to give you a little bit of background information about John. So John was born in Johannesburg and grew up in Johannesburg. He was at St. John's College here, which we will forgive him for, and he trained initially in an arts degree and then moved over to the dark side, one might say. He comes from a family which has many medical doctors in it. Actually, his father was a consultant physician in Johannesburg, and his cousin Tony Sainer headed up our Gauteng branch of SAMA and is a well-known GP in Johannesburg for some time. John moved over to law, where he found his sort of center, and he has always been involved and interested in the medico-legal side of law, most particularly dealing with some of the ways that this has been construed in many ways. Because of his family background, one of the things that John has been able to empathize with is the position that doctors often find themselves in. He is the author of 4 textbooks, Medical Malpractice in South Africa, which has literally almost become the textbook for lawyers in this business, Agreements in Restraint of Trade in South Africa, Prescription in South African Law, and then what brings him to us tonight, his latest book, Basic Law for Doctors. Now, I must tell you, I've had this book for a couple of months now. Most embarrassingly, I still have not yet finished it, but that's not because it's unreadable. Actually, it's almost the exact opposite. It puts the most clear principles, it puts the most difficult to understand principles in the clearest possible terminology. And right throughout the book, John has these little text boxes entitled Vitals, which literally give you the concept in a 1-line or 2-line nutshell. It really is invaluable reading. And as John will tell you, his experience in the South African medical defense, medical prosecution environment has led him to the understanding that most doctors are horribly and woefully unprepared for what they are doing when it comes to this environment. So without any further ado, I'd like to introduce John and let him go ahead with his presentation. Over to you, John.
Thank you very much, Mark. I appreciate it. Good evening, ladies and gentlemen. Although I sit here and I'm coming to you from Tampa in Florida in the USA, it's just after midday here, and it's what we would call a relatively cool day in Florida. It's about 31 degrees in the late summer. It's midday here, as I say, whereas I gather it's early evening there. But welcome to this webinar, and thank you very much for attending. I sincerely hope you'll find it instructive, entertaining, and more than anything else worthwhile. I'm sure, in fact, you will. If you stay with it too, which is worth remembering, it could earn you valuable CPD points. As the kind intro by Dr. Mark Heeman outlined, I'm a senior counsel at the Cape Bar, hence the SC after my name, and I specialize in medico-legal matters, and particularly in medical negligence. My background, as Mark outlined, is essentially a medical one, although I am obviously a qualified lawyer. To add a further doctor to my lineage, my grandfather on my father's side was a specialist surgeon, and he served in the trenches in the First World War, where he in fact picked up TB, and he died from TB in 1923 as a result of his service there. So I come from a long line of doctors, and that is what led me into the medical negligence field. The reason is why I decided to go for it is because, as Mark said, so many doctors I have come across simply are not aware of how the law affects their practice and the consequences of what they do from a legal point of view. I've spent 37 years in practice as an advocate, 25 of those specializing in medical negligence. And as Mark again said, I wrote the textbook for lawyers, medical malpractice in South Africa. But subsequent to that, and that is essentially a technical legal textbook, although I have since discovered that many doctors have in fact bought it and have used it. But what I wanted to do was write a simple, easy to understand textbook for doctors. And that is what gave rise to my book, which you see in the background, the cover of it, with the beautiful design by my daughter-in-law, Beth Sainer. It's called Basic Law for Doctors, Protecting Patients, Protecting Practices. And it's basic because, as Mark said, I have written it in a language and in a format which makes it easy to understand, easy to grasp, and easy to read. And I would urge all of you, not for my sake, but for your own sakes, to get a copy of it and read it, even if you only read it when you're on the toilet, because each of the paragraphs, each of the passages is just about that right length of time for you to do one at a time. Now, I'll very quickly explain what the purpose of the book was, and that was to instruct doctors in the hope that if they understand the law as it applies to them, they will be able to adjust their practices in order to always operate within the law. And if they do that, then they will avoid medical negligence claims. And I'll go on to outline what a medical negligence claim might entail in due course. And I will repeat this at the end, but very quickly, if you want to order a copy, all you have to do is type in your Google search lexisnexus.co.za/store, S-T-O-R-E, all in lowercase, and then enter in the search bar which appears there, Basic Law for Doctors, and the book will come up. Click on the book and you will be able to buy and order a copy. Now, this web address has two aims. Firstly, to introduce you to my book, which I hope I've done, and I'll refer to it again at the end. But secondly, and most importantly, to try and introduce you to the law as it applies to you in the practice, in your daily practice of your professions, in the hope that that will lessen your liability for a medical malpractice suit. There was a pilot launch of my book at the SASMFOS conference, that is the Maxillofacial and Oral Surgeons Conference in Cape Town in October last year. And it was so well received. In fact, I felt like a celebrity signing all the copies in person just for 30 minutes. We decided to give it a big airing at this webinar, which goes out exclusively to SAMA members. I hope you'll buy a copy of my talk. It could just help you to avoid that scariest of events, a medical negligence lawsuit in which you, the defendant doctor, are accused of negligence. Now, the title of this webinar is, What is Medical Negligence? And at the outlet, let me say and answer that question. Medical negligence is a scourge on the profession. Firstly, it bleeds dry the state and provincial healthcare systems, and it continues to do so at a terrifying rate. It deprives them of desperately needed funds for the care of the nation because of medical negligence suits against the practitioners who practice in that sector of the healthcare profession. But secondly, it leaves an indelible and ugly stain on the profession itself as a whole, and on any healthcare individual professional who might be caught up in it. So let's start then at the beginning. Jane Austen starts her famous work, Pride and Prejudice, with a truism, and I quote the very first sentence of the novel: "It is a truth universally acknowledged that a single man in possession of a good fortune must be in want of a wife." For present purposes, that can be paraphrased, and it will be just as true in modern day terms with regard to the medical profession. Quote, "It is a truth universally acknowledged that a medical practitioner in possession of a good practice will not want for a medical negligence suit at least once in his or her professional life." This truism is so because of the exponential surge in medical negligence claims against doctors and against the state in the last 10 to 15 years in South Africa, and indeed in the world, although in countries such as the USA, it of course started much earlier. The reasons for this surge are many, and they are varied. First of all, the long expected but not yet apparent demise of the Golden Goose Road Accident Fund, source of funds for many attorneys. You will no doubt be aware that the Road Accident Fund has been overwhelmed with claims, some good, some bad. But it is because of that, it has been expected that it will crash. It has not yet, but many attorneys have turned their attention to the medical negligence field in the misguided idea that it might in fact provide them with another golden and goose and easy punch bag. The complexities of the medico-legal litigation field have scared many of them off since. Secondly, there's contingency litigation. That is litigation which is undertaken by lawyers, advocates, and attorneys for no pay at all up front and for recovery of their costs only in the event of a positive outcome. It is controlled at present by the Contingency Fees Act, which puts a cap on what can be claimed by lawyers and doctors. Why it has led to a huge upsurge of medical negligence claims is because operating on a contingency basis means that people who never before could have contemplated getting their cases to court can now do so because it doesn't cost them anything at the start of the case. I myself have conducted every single one of my many medical negligence claims on contingency, and I continue to do so because I believe that it is in the service of the less privileged of our society that one does that sort of thing. The third aspect is the degenerating state of most provincial healthcare facilities and the level of service which is meted out. I need hardly, I'm sure, elaborate on that aspect. Finally, there's the shift in emphasis in our medical malpractice jurisprudence from the paternalistic, the doctor is always right, which pertained up to 15 or 20 years ago, to a more patient-centered and patient autonomy approach to medicine. Now, such has been the growth of medical negligence claims that provincial healthcare systems, as you all probably know, are being literally crushed by these claims. The Northwest Province, Mpumalanga, and the Eastern Province, the Eastern Cape Province, are prime examples. In the Northwest, the claims outstanding far exceed the annual budget of that province in the healthcare field. In all provinces, medical negligence claims take a huge slice out of budgets that should be used for patient care. For example, Mpumalanga has recently been ordered to pay one claim, I emphasize one claim, to the tune of 83 million rand. One has only to stop and imagine how much healthcare for patients that amount of money could have provided, and that is just one claim. One major insurance company, for example, that dipped its toes into the medical insurance market had to pull out as it could not sustain the level of claims with which it was hit. Then the hardest hit sectors of the medical profession, such as obstetricians and gynecologists and others, have had their professional indemnity insurance claims increased to almost unaffordable levels. Not too long ago, I was told by an obstetrician gynecologist that her insurance premiums for the year exceeded 1 million rand. She left the profession as a result, and she is not alone. Other similarly affected professionals refuse to practice the obstetrics part of their speciality for fear of litigation. Many healthcare professionals have left and are leaving South Africa for this very reason. I have personal knowledge of this. It is not just a conspiracy theory. In short, as I've said, medical negligence claims are a scourge on and a very real threat to the medical profession. The obstetrician gynecologist fraternity, to go back to them, or maybe sorority, if you will, is having difficulty attracting practitioners into this sector for this very reason. And as I have said, the provincial healthcare services are being bled dry, literally. Some are, to use a metaphor, on their knees, the Eastern Cape being just one. And believe me, from a personal and individual point of view, there is nothing more stressful or harrowing or scary for a healthcare professional than being the object of a medical negligence suit. Such a case can go on, and I don't exaggerate here, for years and years and even decades. Let me tell you about just one in which I was personally involved, the case of Dr. Lowe versus Dr. Patel. It is a case that has spent and is not yet finished 12 years in litigation and 15 years from the time of the shooting which Dr. Patel suffered from. What it meant for the doctor involved? Well, first of all, in the first court of first instance, the case went on for 8 full weeks in court. Can you imagine? The doctor involved had to be in court for most of those court days in order to give on-the-spot instructions to his legal team. He spent umpteen hours in pre-trial preparation. He spent 4 days in the witness box, more than 2 of which were under rigorous cross-examination. And when I tell you that being under cross-examination is possibly the most unpleasant thing you could ever endure, believe me, that is very much the truth. Ask any doctor who has had to endure it. And imagine the hit on your standing and reputation should you be subject to such a medical negligence suit. So, having, I hope, scared the wits out of you, let's, in the word of the Julie Andrews song from The Sound of Music, start at the very beginning, which is indeed a very good place to start. What is medical negligence exactly? What is negligence? Well, for starters, negligence is but one of the elements of what we call, as opposed to a criminal, a civil wrong. In South African parlance, it's called a delict. In England, they call it a tort, T-O-R-T. A delict consists of 4 elements: negligence, unlawfulness, causation, and harm or damage. The first 3 of these elements are always at play at the initial stages, that is the merest stages of a medical negligence case. That is the stage at which one decides whether the doctor in the firing line, in the bull of the target, is in fact negligent or not. Negligence, unlawfulness, and causation, those are the 3. But chief amongst these is always negligence. So what is negligence? Forget the medical part for a moment. In legal and layman's terms, negligence is simply a departure from the actions of a reasonable man or woman. Perhaps if I tell you about the test for negligence, its meaning will become a little clearer. The test in law was formulated a long time ago in a leading case which is still current at present. It's called Kruger versus Coetzee. According to that test, negligence is proved if A reasonable man or woman in the defendant's position would have foreseen that his or her actions might cause harm. So foreseeability of the reasonable man or woman. Then, whether a reasonable man or woman in the defendant's position would have guarded against or taken steps to avoid causing that harm. And C, the defendant failed to take such steps to avoid the harm. Let's just put that in the medical context then, and let's go to this scenario of closing up a patient after a surgical procedure and leaving behind a swab. And we'll get back to that particular scenario as far as actual cases are concerned. But for the moment, let's apply those three situations, those three criteria for negligence to a medical situation, leaving behind a swab. So then one asks, A, would a reasonable surgeon in the defendant's position have foreseen that leaving behind a swab after closing up a procedure would cause harm? The answer to that is obviously yes. Then one asks, would a reasonable surgeon in the defendant's position have guarded against leaving behind a swab after closing up after a procedure? The answer to that is obviously yes. Then the final one, did the defendant surgeon fail to take steps to avoid leaving a swab behind and so avoid the harm? If the swab was left behind, the chances are then that negligence has been proved. But then you may ask, well, if that is the case, who or what is this reasonable man or woman? Does he or she actually exist? The answer is that he or she is very real in legal terms, but fictitious nevertheless. Descriptions of this ephemeral being vary from case to case, but all descriptions agree that this person, quotes, lacks exceptional qualities, close quotes. In other words, he or she, in South African terms, is Jan Alleman, just an ordinary Okie or Dharmaki, not too clever, but by no means dumb or stupid, and with solid common sense. In English terms, he or she is the everyday person on the Clapham omnibus, the ordinary man or woman in the street. Perhaps the best and most colourful description of the reasonable person was penned by that great jurist and one who had a flair for writing beautiful and eloquent judgments, that is Holmes J.A. He said, quote, one does not expect of a diligens paterfamilias, that is Latin for a reasonable man, any extreme such as Solomonic wisdom, prophetic foresight, chameleonic caution, headlong haste, nervous timidity, or the trained reflexes of a racing driver. In short, a diligens paterfamilias treads life pathway with moderation and prudent common sense. In short, the criterion, close quotes. In short, the criterion of the reasonable person is the embodiment of an external and objective standard of care, and that applies in the medical field as well. What is reasonable in a particular case is something ultimately which the judge in charge of that case decides according to the facts, but it is always an objective, not a subjective standard at all times. It is what is reasonably foreseeable and reasonably able to be avoided. But how then does this concept of objective reasonableness translate to medical negligence, you may ask? In the case of the medical profession, the standard is that of a reasonable practitioner in the same circumstances as the defendant, doctor, or healthcare professional. In other words, if the defendant is a GP, then he or she will be judged against the standard of a reasonable GP in those circumstances. And circumstances matter. a different standard of care would be expected of a reasonable GP in a fully equipped and staffed modern hospital than of the reasonable GP in an isolated farmhouse with no electricity or running water. Therefore, in a court case where, for example, a GP was the defendant, the plaintiff and defendant would most likely call another GP as an expert to inform the judge presiding as to what a reasonable GP would do in those circumstances and what he or she should have done. And the same would apply if it was an OBGYN who was the defendant, for example. So as you can see, the reasonable doctor is at once fictitious in that he or she does not actually exist, and yet he or she inhabits every medico-legal case with a fluid and adaptable set of middle-of-the-road characteristics, not too competent, but not incompetent, just reasonable and down the middle of the road. Let me illustrate this, going back to the forgotten post-operative swab situation, with reference to the interesting and seminal case which some of you might have come across of Van Wyk versus Lewis from the Appellate Division in 1924. Yes, it was decided 100 years ago, and it still applies. In Van Wyk versus Lewis, Dr. Lewis was a surgeon. He was a practitioner, a rural practitioner, and he performed a difficult abdominal operation in the operating theatre of a rural hospital at night. He was assisted by an anaesthetist and by a trained sister who acted as a theatre nurse, a theatre sister, in the circumstances. After he had performed the operation, they closed up the plaintiff, who was a female, and the doctor and the nurse communicated with each other and were happy that all of the swabs had been accounted for. Unfortunately, this was not the case, because 12 months afterwards, the plaintiff passed a swab from her body, and it became common cause after some toing and froing in the court that the swab must have been left behind after the procedure 12 months before. She suffered certain complications as a result of having this swab in her body for that length of time, and she sued Dr. Lewis for negligence. After hearing evidence from medical practitioners and in fact from specialists on both sides, the court concluded that in the circumstances, each of the people in the theatre, although they were under the overall control of the Dr. Lewis, the surgeon, they each had separate and independent functions to perform. And from the evidence, it was apparent that in this particular operating theatre, and when this nurse had worked with a doctor before, one of the aspects was that she had an independent responsibility for ensuring that all of the swabs were accounted for. And they found that the doctor was entitled, although he was in overall control, again, of all that went on in the theatre, he was entitled to rely upon her say-so that all the swabs had been accounted for. As he was the only one that had been sued, and as he was entitled to rely upon the say-so of the theatre nurse, he was absolved of negligence. The nurse had not been sued, and she was therefore not liable either, although the court hinted that she might very well have been liable for negligence. What the case illustrates is that it is always the particular circumstances of a particular case which will determine whether there has been negligence or not. Now, Van Wyk's case is informative, and as the courts have said, that in assessing the attributes of a doctor, and this is what Van Wyk's case said, a court will, quotes, have regard to the general level of skill and diligence possessed and exercised at the time by members of the branch of the profession to which the particular practitioner belongs. And in Van Wyk's case, they had regard to all of the levels of competence of all of the professionals, and they decided that Dr. Lewis had acted in accordance with his level of expertise and in accordance with his practice as far as working with the sister nurse was the nurse in charge of the operating theatre was concerned. Now, the logical extension of this is that a GP is judged against the standard of a reasonable GP in the same circumstances, and a maxillofacial and oral surgeon is judged against the standard of a reasonable max for in the same circumstances. And the same goes for a neurosurgeon and a physiotherapist, and in fact, any healthcare provider. In line with the middle-of-the-road characteristics of the reasonable person, the law does not hold an expert such as a medical professional, even a specialist, to the highest level of competence, just because he or she is well qualified and highly trained in his or her field. Rather, he or she is held to the level of competence of a reasonable medical professional who professes to have the same skills as the medical professional in the firing line. Therefore, in a court case where, for example, a GP was the defendant, the plaintiff and defendant would most likely call a GP as an expert to inform the judge presiding what a reasonable GP would have been expected to do in the same circumstances. And the same would apply if an OB/GYN was the defendant, for example. So, as you can see, the reasonable doctor is at once fictitious, in that he or she does not actually exist, and yet he or she inhabits every medico-legal case with a fluid and adaptable set of characteristics depending on the circumstances. Not too competent, but not incompetent, just reasonable and down the middle of the road. Contrast now, for example, completely that case of Goliath versus MEC for the Eastern Cape on very similar facts to that of Van Wyk versus Lewis. In that case, it was held that the medical professionals involved in the operating theatre were liable because collectively they were responsible for seeing that all swabs were removed before closing up on the patient. Again, a swab was left behind, which was later extracted. Why the difference in result on such similar facts, you might ask? Well, the two cases are clearly distinguishable. In Van Wyk's case, only the surgeon was sued, as I've said, and he was not ultimately responsible for the final swab count. The theatre sister was. Therefore, he was not liable. But in Goliath's case, the MEC for health was sued. And since he or she was responsible for the negligence of any and all of the medical healthcare employees under the doctrine of vicarious liability, it did not matter, in fact, who was responsible for leaving the swab in the patient. To leave it there was negligent, and someone in the theatre had left it there, and therefore the MEC was liable. A fine but clear distinction. As I've said, at the end of last year, I gave a similar talk to the Congress of Maxillofacial and Oral Surgeons in Cape Town. To my surprise, I could find no reported case involving a maxillofacial and oral surgeon. I concluded that they must all be either very skilled or careful, or just plain lucky, or very good at fixing up their mistakes. But there is one reported and instructive case where a Max 4 surgeon is at least peripherally mentioned. It's Rowe versus MacDonald, the appeal case. It involved an alleged failure by a dentist to refer the patient to a specialist, in this case, a Max 4 surgeon. And again, it involved what a reasonable medical practitioner ought to have done in the circumstances. By way of preamble, a failure to refer appropriately may, depending on the circumstances, constitute negligence. And because the practitioner concerned did not have the necessary skill to treat the patient, and the reasonable practitioner would therefore have referred the patient on to someone who in fact did have the necessary skill. In MacDonald v. Rowe, the defendant, a general dental practitioner, extracted 3 of plaintiff's wisdom teeth. It was a procedure he had done hundreds, if not thousands of times before. But during the procedure, the patient suffered trauma to the inferior alveolar nerve on the left side of her face. This resulted in a feeling of numbness and pins and needles, and these sequelae were permanent. She sued the defendant, amongst other things, for negligently failing to offer to refer the patient to a specialist maxillofacial and oral surgeon for the removal of the wisdom teeth. The case was made that such a surgeon would have had more expertise and would not have injured the alveolar nerve. The trial court accepted, however, after evidence from experts, that the defendant had the necessary skill to perform the surgery correctly and had in fact done so, and had not performed the surgery negligently. On appeal in Roe v. MacDonald, the court upheld the finding that the defendant was not under a duty of care to have referred the patient to a specialist because he had the necessary skill to perform the procedure anyway. In other words, to look at it from the other side, a reasonable general medical dental practitioner would not have referred the patient because he had the necessary skills, so the non-referral was not negligent. So the Max 4 surgeon was not liable, and of course neither was the dentist. The corollary of this decision is that a failure to refer by a healthcare professional who is not equipped to deal with the situation constitutes negligence, a failure to refer appropriately. It is interesting to note that the fact that the patient was harmed in Roe's case did not necessarily mean that there was negligence. This is because some procedures, as you all know, and as the court found, have inherent risks which might eventuate even in the hands of the most skillful and careful practitioner. So, provided the practitioner has obtained the patient's informed consent by informing his or her of the possible risks, and we will get into informed consent at the end of this talk, the practitioner will not be liable because the patient has voluntarily assumed the risk of the harm by giving informed consent to the procedure. And of course, as we have mentioned, if the procedure has risks which would eventuate even if the most skilled professional was to undertake that procedure, then of course there will not be negligence. On the subject of referral and of negligence, should be understood that it can take many forms. Let me go through a recent case which has played out in 4 different forums in South Africa, going all the way up to the Constitutional Court, as medical negligence claims can. That is the case I've mentioned already of Lowe versus Patel, Dr. Lowe versus Dr. Patel. The interesting facts were as follows. Dr. Patel had just closed up his surgery in Standerton, his small surgery in Standerton, at 5:30 in the afternoon. Immediately thereafter, there was a knock on the door and 2 patients, so-called patients, presented themselves and asked if he could treat them. He reluctantly invited them into his surgery, and no sooner had he done so than they proceeded to assault and pistol whip him. They knocked him to the ground and threatened to kill him unless he handed over money. He told them that there was no money in the practice, but that they could take anything they wanted, but please to spare his life. They became angry at this, took what was for the taking, and fired 5 shots at Dr. Patel. 2 of them missed him completely. 1 grazed his hand and left a scar across the middle of his palm. Another one hit him on the forehead and again grazed his forehead and left a scar on his forehead. Unfortunately, the 3rd one hit him while he was kneeling on the ground in the upper medial part of his thigh, traveled down through his leg, through his knee, and exited again in the medial part of his upper calf. It snapped his femur, and it also transected his popliteal nerve, and it transected, most importantly, his popliteal artery. Dr. Patel at once realized what had happened to him and how serious his condition was. Fortunately, his wife summoned one of his colleagues who attended on him immediately, and the paramedics were very quick to arrive. The long upshot of it was that he was taken to the casualty section of Standerton Hospital. He arrived there at about 6:10, so 40 minutes after the shooting. There, He was attended to a few minutes after his arrival by Dr. Lowe, who had been on duty at his practice and who was summoned at Dr. Patel's instance to tend to him. Dr. Lowe, within minutes of examining Dr. Patel, realized, because of the absence of a pedal pulse, that Dr. Patel had suffered a popliteal arterial injury. Dr. Lowe also, under cross-examination, realized that this was an emergency and that there was a finite window of opportunity for a revascularization to be performed in order to re-perfuse the leg and save it. Dr. Lowe also realized that this window of opportunity was somewhere around 7 hours. Dr. Lowe gave evidence, and it was accepted that on the night he had arranged at 6:30 to do an elective appendicectomy, which was, one could, and if you should see a cat, it's because my cat has just jumped on the table. The perils of doing these sorts of things from home, that he realized that Dr. Patel needed to be transferred, but despite this, he decided to, rather than arrange the transfer, to go and do the semi-urgent appendicectomy, elective appendicectomy. He finally arranged the transfer of Dr. Patel after the appendicectomy at 7:30. It was common cause that the provincial ambulance at Standerton Hospital could not convey Dr. Patel because he was a private patient. An ambulance privately needed to be summoned, therefore, from Secunda. The ambulance was duly summoned by Dr. Lowe after making a few phone calls to find out where to get the ambulance. It took a considerable amount of time to come from Secunda. Dr. Patel was uploaded and he was transferred off to Pretoria East Hospital, which Dr. Lowe had assumed, because it was a very large hospital, had the necessary facilities. The reason that he was referred to Pretoria East Hospital was because, and again it was common cause, Dr. Lowe did not have the expertise to do the revascularization. There was nobody in Standerton who could be called to do it, and Standerton Hospital did not have the necessary revascularization facilities. So a referral was required, and quite correctly, Dr. Lowe referred Dr. Patel to Pretoria East. Unfortunately, however, Dr. Lowe omitted to check that Pretoria East, in fact, had a vascular surgeon and revascularization facilities. It turned out on the evidence that Pretoria East did not have those facilities and had never had them. Dr. Lowe had omitted to phone forward to the orthopedic surgeon on duty in the trauma section of Pretoria East that night to warn him that a case was coming and what the particular problems Dr. Patel was suffering from were. The evidence from that trauma surgeon at the trial was that had he been informed by Dr. Lowe, he would immediately have told Dr. Lowe that they could not handle it and would have asked Dr. Lowe to reroute Dr. Patel to a level 1 trauma unit close by or closer by. Dr. Patel, when he arrived at Pretoria East, had to be rerouted by a shocked trauma staff who immediately realized that he had a popliteal injury which was advanced. He was bundled up, placed in the ambulance, and rerouted to Pretoria Heart Hospital, where a revascularization took place. Unfortunately, that procedure, which did in fact reperfuse his leg, was too late. It finally achieved revascularization 9.5 hours after the shooting. The leg wasn't too far as necrosis and the compartment syndrome was concerned, and it had to be amputated. Not surprisingly, perhaps, the full court on appeal and the Supreme Court of Appeal unanimously found Dr. Lowe to have been negligent. They found him to be negligent in two respects. First of all, his failure to act timeously. They held that once he realized that the situation was as urgent as he realized it was, and that a popliteal arterial injury had taken place, he ought immediately, irrespective of the semi-urgent elective appendicectomy, he should immediately have arranged the transfer, which could have been done in a matter of minutes. In that, he was negligent. They also found that his failure to refer appropriately was negligent, namely to refer Dr. Patel without checking to a facility which did not have the necessary expertise and equipment to do the revascularization. Dr. Lowe, therefore, was held by the Supreme Court of Appeal to be liable in a judgment 3-2, although the finding on the question of negligence was unanimous. Causation was the tipping point. He was therefore liable, or rather NPS is therefore liable to pay Dr. Patel damages. And this case, the quantum of Dr. Patel's damages have not yet been decided or agreed. So the case continues, and it still continues to hang over Dr. Patel. So from this, we can see that a reasonable GP, and Dr. Lowe wasn't just a GP, a reasonable GP in the circumstances of Dr. Lowe would immediately have arranged for a transfer once the vascular injury was diagnosed. This Dr. Lowe did not do, and on the Kruger versus Coetzee test, therefore, plainly, he was negligent. Secondly, Dr. Lowe did not check that the Pretoria East Hospital, especially in light of the extreme emergency of the situation and the distance from Standerton to the Pretoria East Hospital, he did not check that it had the necessary facilities. In that, again, on the Kruger versus Coetzee test, he was negligent. In the circumstances, the second part of in fact, both parts of the negligence finding constituted an error of judgment on the part of Dr. Lowe. But that raises the question, which I'm sure is at the tip of all of your tongues: are all errors of judgment by medical professionals necessarily negligent? The answer, you will be relieved to hear, is no. The test is and remains, and I quote, whether the practitioner exercised reasonable skill and care, or in other words, whether his or her conduct fell below the standard of a reasonable, competent practitioner in his or her field. If the error is one which a reasonably competent practitioner might have made, it will not amount to negligence. So that emphasis on an error which the reasonably competent practitioner might have made, it will not amount to negligence. In short, you will be pleased to hear the South African law of medical negligence recognizes that, gasp, doctors are human beings and not machines. They are not infallible. That is, it is human to err, sometimes. So the law recognizes that some mistakes lie beyond the bounds of the standard of a reasonably to be expected of a reasonable medical practitioner. Let's illustrate that in the best possible and most interesting way by reference to some decided cases, some English, some South African. And in fact, our law in this aspect is informed by English law principles. Firstly, let's go to Pringle versus the administrator of the Transvaal. For the younger of you around, the Transvaal is now Gauteng. In Pringle's case, the vena cava of a patient had been perforated during a mediastinoscopy. The surgeon in question, under cross-examination, admitted that in trying to remove the offending lymph node, he had, quotes, tugged too hard on the forceps he was using to do so. he had thereby caused the vena cava to rupture. He also conceded that, under cross-examination, he must have used excessive force in that part of the procedure. Now, the court took into account the evidence of expert witnesses to the effect that this was a very difficult operation in what the court called a surgical minefield in that area of the body. But it found, applying the test of the reasonable specialist, that the defendant, in using excessive force, had not just committed an error of judgment in doing so in his modus operandi. In fact, it found that his actions showed that he had not applied that skill and diligence possessed and exercised at the time by members of the branch of the profession to which he belonged. He was therefore held to be negligent. Now let's contrast that case with that of Whitehouse versus Jordan, an English case. In that matter, it was alleged that the defendant obstetrician had been negligent in that it was alleged that he had, in a very complicated delivery, applied a pair of forceps to and had then pulled too hard and too long on the extended head of a baby, causing serious brain damage. The question was whether he had merely made a clinical or professional error of judgment. The court dismissed the notion, which was argued on the obstetrician's behalf, that a clinical error of judgment cannot ever amount to negligence. Lord Fraser said, and this is true in South Africa, quote, "The true position is that an error of judgment may or may not be negligent. It depends on the nature of the error. If it is not one that would have been made by a reasonable, competent professional, professing to have the standard and type of skill that the defendant held himself out to have, and acting with ordinary care, then it is negligent. If, on the other hand, it is an error that a man acting with ordinary care might have made, then it is not negligence." The House of Lords upheld the appeal court's finding that on the evidence, the specialist had not pulled too hard or too long, and that even if he had, the action could, in the circumstances, have constituted only a forgivable clinical error of judgment and was not negligent. Such an injury could have occurred, so the court held, even if the procedure was carried out with due care and diligence. As you will appreciate when one juxtaposes these two cases, there is a fine line between what is or is not a negligent error of judgment. That this is so is highlighted by the facts and outcome in the case of Buthelezi versus Ndaba. Here the court found that the negligence of a defendant doctor had not been proved, despite the fact that an injury had resulted from the procedure he had performed. The expert evidence led in that case was to the effect that that the fistula that occurred during a procedure could have resulted despite the application of reasonable skill and care. Since this viewpoint was supported by expert evidence and opinions in international medical journals, the infliction of the injury, interestingly enough, the cause of which the defendant could not explain. In thinking back, he could not think of how the injury could have occurred, but it was common cause that the injury had in fact been incurred during the procedure. That the injury, because the injury had occurred, the court found that this could not simply be ascribed to negligence. The surgeon was not, just because something had gone wrong and harm had ensued, to be held negligent. Without proof that he had committed a clinical error of judgment, which was negligent, it could not be held that in fact he was negligent. The court therefore held on the expert evidence that the injury could have occurred even in the hands of a competent, reasonable surgeon. In summary, then, you will be pleased to hear that the law does not require a doctor to be infallible in his or her conduct. An error of clinical judgment will not constitute negligence if a doctor has adhered to the requisite standard of reasonable care. But if the error is one that would not have been made by the reasonable medical practitioner in the circumstances, then the action will be negligent. Ultimately, therefore, as Scott J. said in the case of Castell versus de Greef, a case concerned with consent mainly, quote, "The test remains always whether the practitioner exercised reasonable skill and care, or, in other words, whether or not his conduct fell below the standard of a reasonable, competent practitioner in his or her field. If the error is one which a reasonably competent practitioner might have made, it will not amount to negligence." Now, let's get on to the question of misdiagnosis, something which probably scares a lot of you, particularly when faced with a complex diagnostic problem. What about a misdiagnosis or an incorrect diagnosis? Is that necessarily negligent? Not surprisingly, the same principles apply. A wrong diagnosis is not necessarily negligence. As was said in the old and seminal case of Mitchell versus Dixon, it's a case which was decided in 1914 by the Appellate Division, 110 years ago, still current. Quote, "Now, a medical man is not necessarily liable for a wrong diagnosis. No human is infallible. And in the present state of science, and that applies even in today's medical negligence field, even the most eminent specialist may be at fault in detecting the true nature of a diseased condition. A practitioner can only be held liable if this respect of his diagnosis is so palpably wrong as to prove negligence. That is to say, if his mistake is of such a nature as to imply an absence of reasonable skill and care on his part, regard being had to the normal level of skill and care in his part of the profession. So, if a reasonable doctor at whatever his level, having performed a thorough examination and assembled all the facts, would have come to the same diagnosis, even if it is wrong, then there is no negligence. This is the basis of part of the decision in Mitchell's case, and that standard is still applied today. A leading case on misdiagnosis is that of Blythe versus van den Heever. One of the central issues in this case was whether a reasonably skilled and careful medical practitioner in the position of the respondent orthopedic surgeon would have realized in the circumstances that a serious ischemic condition was developing or threatening to develop in the appellant's severely injured forearm, which the surgeon had treated. And if a reasonable practitioner would have done so when he or she could reasonably have been expected to realize the development of this threatening condition. The court held, after hearing all of the expert evidence, that a reasonably skilled and careful medical practitioner in the position of the respondent and based on his own observations, which were contained in his notes, would have been aware of the danger of an ischemic condition developing in the appellant's forearm. In the circumstances, the court found, as I've said, the respondent's own observations noted by him to have been sufficient had they been correctly interpreted by him, as a reasonable surgeon in his position ought to have done, to have alerted him to the real danger of an impending ischemic condition. In failing to diagnose impending ischemia, or even to suspect the possibility of such a condition developing, he was negligent because he failed to display the skill and care reasonably expected of him in the circumstances. A further reason, so it was held, why he had failed to make the correct diagnosis and was therefore negligent was that he was not sufficiently vigilant in light of the symptoms confronting him at the time in question in the development of the appellant's condition. He had, in fact, allowed 24 hours to elapse between visits during a critical period, and even when he was telephoned by the appellant's sisters and told of their concerns, he did not go and examine the appellant himself. In this, he was negligent, as his failure to diagnose or foresee the ischemia sufficiently early, or to take steps to facilitate that diagnosis that he should have done, led to a catastrophic failure to treat accordingly. The arm, like Dr. Patel's leg, ended up useless. In fact, the arm ended up what the court described as nothing more than a useless claw. The final case worth considering in the realm of a misdiagnosis is that of Bulls, B-U-L-S, versus Tsatsarilakis, mainly because it describes with admirable clarity the correct approach to deciding whether a misdiagnosis should give rise to liability. In essence, the court decided that an ordinary casualty officer, a GP in this particular instance, on duty in a trauma unit in a private hospital, was not liable for failing to diagnose a scaphoid fracture in the wrist of the plaintiff. The plaintiff had presented on the night to the defendant doctor, who had examined him. His wrist was extremely painful. The doctor suspected a fracture and had the wrist x-rayed. Neither the defendant nor the specialist radiologist, who subsequently reported on the x-ray to the defendant, in fact detected a fracture. The plaintiff's wrist was duly strapped with an adhesive bandage. He was given tablets to reduce the swelling and told to return in a week. When he did return, the pain had diminished and the swelling had almost disappeared. The defendant doctor took comfort from this. After giving him further medication, the defendant told him to come back if the pain persisted. The pain continued, but the plaintiff never returned. 3 weeks later, an orthopedic surgeon diagnosed a fracture of the scaphoid, a diagnosis which the defendant had clearly missed. In deciding what standard of care had to be applied, Nicholas J., the presiding judge, said, quote, "The standard of care required of a medical practitioner who undertakes the treatment of a patient is not the highest possible degree of professional skill, but reasonable skill and care. And the test to be applied is not what a specialist would or would not do under the circumstances, because a general practitioner, as was the doctor in this case, is not expected to have the same degree of knowledge and skill and experience as a specialist has. The question is, what is the common knowledge in the branch to which the accused, the doctor, belongs? Consequently, after reminding itself that the evidence of experts is of great assistance, the court reiterated that what is reasonable in the circumstances is ultimately for the court to decide. In the final analysis, in absolving the defendant himself from all liability, the court decided that regarding how the defendant had in fact carried out his treatment, the court said, quotes, "His conduct was that which we would have expected from an ordinary casualty officer. Dr. Bulls was not an expert in problems of the type which arose, and he gave it the attention of a general practitioner. The fracture of the scaphoid bone is a very difficult one to diagnose. At the interview on 14 April, Dr. Bulls was reassured clinically by the fact that the swelling had gone, if not completely, then at any rate substantially, and that the pain had reduced. He had been informed by the hospital's radiologist that there was no fracture visible on the x-rays, and the average doctor, that word average, would have accepted that opinion, as did Dr. Bulls. He told the plaintiff that if the risk continues to trouble him, he should come back. In light of the evidence and having regard to the onus, it is impossible to hold that the plaintiff established the negligence referred to." Thus, one can see from these cases, and particularly from Dr. Bull's case, just how careful South African medical law as applied by the courts is in recognizing that medical practitioners are, as I've said, human and fallible, and that more expertise is never expected of a doctor than what he or she has been trained to apply. Now let's come to a very different topic, and one which some of you might have faced, but I'm sure which all of you have contemplated at some stage, and that is the question of the so-called Good Samaritan doctor. It's a topic I'm sure you want to all hear about. Some of you may have been caught up in an emergency situation and have been uncertain how to react. I'm talking about that moment in a public place, in a movie house or a plane, where the cry goes up, "Is there a doctor in the house? We have an emergency." What do you do? Are you obliged to do anything by law? And if you do step forward, and will you incur liability if the treatment you render is not successful? And if you do not step forward and it becomes known that you as a doctor were present, will you incur liability for your passivity? The dilemma you will then be confronted with in just such a scenario is mirrored by the dilemma in South African law. That dilemma is that whilst our law of delict frowns on the party who causes harm to another, in other words, if you smack somebody over the head, that's a delict, or even by means of an omission to do something if you injure somebody, South African law, it's important to note, imposes no legal obligation to act when there is no legal duty to do so. Let me illustrate that with a simple example. You're on the banks of a river when a woman next to you falls into the fast-flowing water. Her husband, the only other person there, turns to you and says in a panic, "I cannot swim. If you can, please save her. She cannot swim." You can swim very well. In fact, you've been trained in life-saving procedures. In these circumstances, you might be interested to know you will incur no legal liability if you stood and watched that poor woman drown. There's no duty in South African law on you to save her. You might be somewhat unpopular, however, with her husband, but that would be from a moral point of view. As I say, there is no legal liability in that situation. In the medico-legal situation, or between doctor and patient, there is a legal duty on the doctor to treat his or her patient, where there is a doctor-patient relationship, with reasonable skill and care, we have since discovered. But in an emergency situation, there is, of course, no legal relationship between the ailing person and the serendipitously present Good Samaritan doctor, as there was indeed not between you and the drowning woman. At this point in time, the issue, interestingly enough, has never been decided in the courts in South Africa, particularly as regards a single private practitioner's obligations in an emergency situation. It has come before the courts in the context of public, that is provincial health facilities, in a case known as Subramuni's case. There it was held that a person who suffers a sudden medical catastrophe cannot be turned away from a provincial hospital, no matter what the circumstances. This decision was not, however, precedent-setting because the court decided on the facts of that case that the condition of Mr. Subramuni, which was kidney failure, in terms of which he needed urgent dialysis and which he could not afford, and which was available at provincial hospitals, that was not a, quotation marks, emergency, close quotation marks, in the circumstances. But what that court did hold was that section 27(3) of the Constitution, which provides that, quotes, "No person may be refused emergency medical treatment," close quotes, requires that remedial treatment that is available and necessary must be given immediately to avert harm in an emergency, at least by a public or provincial hospital or medical facility. Here we must deviate slightly to look at the element of unlawfulness in delict, which I mentioned at the start of my address. To cut a long story short, in negligence, to be actionable must also be unlawful in the circumstances. A failure to do something when there is no duty to act is not unlawful, as I have mentioned. So because in the drowning woman case there is no duty to act, your failure to jump in the water and save her is not unlawful and therefore would not be actionable, even if it could be held to be negligent. But where there is uncertainty, as with an emergency situation, a medical practitioner's duty to act, the courts must decide as a matter of public policy whether a failure to act is in the circumstances unlawful and therefore actionable. So liability will result when the legal convictions of the community, as decided by a court, that is to say public policy, regards the conduct, the doctor's failure to act, as unlawful and wrong. Now, I am of the opinion, as are a number of other academic and legal writers, that a court may very well hold a doctor liable in South Africa for harm suffered by an injured or sick person in a genuine emergency situation in circumstances where the doctor was aware of that person's condition and unreasonably refused or failed to attend to him or her. Now, there are several strong, I believe, reasons for this. Namely, first of all, as I've mentioned, section 27(3) of the Constitution, which provides no person may be refused emergency medical treatment. Note that it says refused as opposed to every person is entitled to emergency medical treatment. And in that semantic conundrum lies a legal argument, which we won't get into now. There are certain ethical rules of the HPCSA which indicate that a doctor must act in an emergency. For example, booklet 1 in paragraph 5 provides that a medical healthcare practitioner must, quotes, in emergency situations, provide healthcare within the limits of their practice and according to their education and or training, experience, and competency. Booklet 2, paragraph 21 provides a practitioner shall perform, except in an emergency, only a professional act for which he or she is adequately educated, trained, and sufficiently experienced. Again, implying that action must be taken in an emergency situation. And booklet 2, paragraph 27a, little g, enjoins a healthcare professional to, quote, obtain informed consent except in an emergency, implying that action in an emergency, again, is required. And of course, Section 5 of the National Health Act, which is the overall governing piece of legislation of the provision of healthcare in this country, provides a healthcare provider, health worker, or health establishment, and you're all healthcare providers, may not refuse a person emergency medical treatment. All of the above, I think, convincingly indicate that there is a duty on a doctor to step forward in appropriate circumstances and act if the circumstances demand such action. The particular circumstances are always important. Such circumstances would include a true emergency. And a true emergency means that the circumstances are such that the injured or sick person might die or suffer serious or irremediable harm if the doctor in question does not step in. So a minor condition where they call for a doctor and no one else is present except yourself would not necessarily mean that you have to step forward. There has to actually be a question of mortality or of serious irremediable harm. Secondly, the Good Samaritan doctor has to have the necessary skills and training to deal with the injury or ailment. That does not mean that if there is a cardiothoracic problem or a heart problem, that you would have to be a cardiothoracic surgeon or a cardiologist in order to be required to step forward. All that is required is that you have some skill and training which would be of assistance in remediating that particular emergency situation. Then, of course, the circumstances must be such that the Good Samaritan does not have a similar or more urgent or immediate call on his or her skills. That is to say that you are on the way to another patient who requires your urgent or semi-urgent care. Then the situation must be such that there is no alternative except for the stepping in of a Good Samaritan doctor. And finally, that of course that there is no danger that the Good Samaritan, when rendering treatment, is put in danger himself or herself. The example therefore, of course, of a road accident victim where you come upon somebody lying in the road and there are cars whizzing by, you would not be expected to put yourself in harm's way by kneeling in the road and risking being injured by passing vehicles. I would therefore urge all of you, as I'm sure you would, to step up in an emergency situation and offer what help you can, even if it is, strictly speaking, outside your area of expertise. If you do not, and the above circumstances apply, you may very well be liable. Now, on the question of liability, what of liability if you do step forward and the patient suffers harm or dies? Well, the reasonable doctor will come to your assistance in that case. How, you ask? Well, by applying the yardstick of the reasonable doctor to your actions in the particular circumstances. This means that, say you are an OBGYN and you step forward to help somebody having a cardiac arrest. In those circumstances, you will be judged by the standards of a reasonable OBGYN in those circumstances. The court will receive evidence and will ask what could and would a reasonable OBGYN in those circumstances have been expected to do? And did you do those things? You will not be expected to come up to the level of a cardiologist or experienced paramedic or even of a GP. It will be the standard of an OBGYN in those circumstances. Similarly, a GP who renders assistance in a situation where the expertise of a cardiothoracic surgeon is required will be measured against the reasonable GP's actions in those circumstances, not those of a reasonable cardiothoracic surgeon or cardiologist. Perhaps finally, let me deal very briefly with the important topic of consent. Firstly, why is it even necessary? Well, consent to any type of medical examination or treatment, whether diagnostic or therapeutic, is the fundamental starting point before any such examination or treatment can lawfully commence or be undertaken by a healthcare provider. This is because patients have a clear common law and indeed constitutional right to their bodily integrity and security. Hand in hand with this right goes the concept of patient autonomy and the right to self-determination, the latter being enshrined in the Constitution. Patient autonomy in the current context entails giving a patient precedence in deciding what, if any, medical intervention may be performed on his or her body, and the concomitant right of a person with full legal capacity to refuse treatment, no matter how potentially harmful such refusal might be, even to the point of death. This approach was explicitly expressed by the Supreme Court of Appeal in R.B. versus Smith, a case dealing specifically with informed consent, when the court said, quotes, "In claims for damages based on negligence for failure to warn a patient of material risks or complications attendant in a treatment or surgical procedure, courts employ a patient-based approach. The reasoning is that a patient's freedom of self-determination includes the right to decide whether he or she wants to undergo surgery or any type of treatment for that matter. A patient is entitled to refuse medical treatment. If he or she consents to surgery or medical treatment, he or she accepts responsibility for unintended harm in the medical treatment. Consequently, the courts in South Africa have held that, quotes, "It is clearly for the patient to decide whether he or she wishes to undergo the operation in the exercise of the patient's fundamental right to self-determination." It follows that in South African law and in many jurisdictions around the world, a healthcare provider cannot so much as lay hands on or examine or treat or diagnose in any shape or form any patient without that person's informed consent. That consent constitutes a valid legal ground or justification for the practitioner's subsequent treatment, no matter how mild or gentle or painful or invasive it might be, even to the incision made in a surgical procedure, which would otherwise be regarded as a stab wound. Consequently, if treatment is rendered without the passenger's informed, and I stress informed consent, it is unlawful and the practitioner involved lays himself or herself open to civil liability or criminal injuria. That is a violation of the dignitas or bodily integrity or privacy of the patient. This is even the case if the treatment in question was, in the opinion of the practitioner, or even objectively speaking, administered with due care and skill and proves to be in the very best interests of and beneficial to the patient. In short, informed consent effectively operates as a justification for the unlawful medical intervention in question. There is that concept of unlawfulness again. It is unlawful and wrong to treat someone without their informed consent. In fact, to treat someone without informed consent constitutes, as I've said, an assault on them. Some jurists see this as a physical assault, that is to say, for example, an unconsented to operation, but I prefer to see it as an assault on their bodily or emotional integrity or dignity. But that's a jurisprudential issue we don't really need to explore right now. Consent, to be effectively valid, and it's very important that it is legally valid, must be comprehensive and given freely and voluntarily after all, and I stress all, the necessary information about the nature and possible consequences of the proposed intervention and its alternatives, including those pertaining to a failure to give or accept treatment or a refusal of treatment, has been given. It follows that a medical practitioner may be liable when there is no informed consent at all, or when the consent is not fully informed and is lacking in some material respect. Important aspects of the consent to be obtained so that it is effective is that material risks must be put to the patient. Now, this is a crucial part of consent. And risk is material if a reasonable patient, if informed of the risk or danger, would be likely to attach significance to it. Or if the practitioner should reasonably be aware that the patient, if warned of the danger, would be likely to attach significance to it. So if the risk is very small indeed, it's unlikely that it would be regarded as a material risk. But if, for example, one was dealing with a concert pianist and there was a procedure being done to the hand or to the fingers of that concert pianist, and there was a very small risk that there might be permanent or even semi-permanent damage to the fingers or to the functioning of that hand, that might very well be a material risk to a concert pianist, which might not be a material risk to the ordinary laborer who only uses his hands in gross motor situations. Now, let me come to what I will call tips for you, something to draw from this talk that I have given you, which I hope has at least been informative. I'm sure you've been waiting for this, as you've been waiting probably for the end of the presentation. First of all, when you have obtained full informed consent, keep detailed, contemporaneous, dated notes of what you have told the patient and their reaction in each instance, and particularly of each step of the consented to treatment. Have those notes countersigned by the patient if you can. I say this because patients' memories of what they were told by their doctor are notoriously bad. They hardly ever listen anyway to that part of the consultation. I've experienced this firsthand when consulting with patients. Fulsome notes will always trump a patient's memory. In fact, keep detailed, legible, contemporaneous notes for all that you do with regard to a patient. Please note that I say detailed, contemporaneous, and legible notes. I have withdrawn many cases from litigation in the face of a suitably detailed set of doctor's notes. They are absolutely invaluable as far as your defense is concerned. They are worth their weight in gold to you and your legal advisors, even to the extent where if your notes indicate that you were negligent, it means the case can be settled quickly and to the best possible advantage. And it means that if necessary, and the MPS very often does this, if the case is settled out of court, it can be settled on the basis that you admit no negligence and the settlement is kept quiet. So notes are extremely important, but particularly as far as consent is concerned, make those notes and get the patient to just initial those notes and then put them in the file and keep them there. Secondly, and very importantly, if something goes wrong or you make a mistake, do not be afraid to apologize. Now, I know in one of the recent editions of Medical Brief, which some of you might get and read, there was an article, I think by MPS, to the effect that there are dangers to be involved in apologizing. Let me make a clear distinction. There is a clear distinction to be made between an apology and an admission of liability or fault. And it's not difficult to distinguish between the two. Saying you are sorry is not an admission of liability, and I would counsel any and all of you, should you make a mess, as inevitably you probably will do at some stage in your careers if you have not done so already, apologize for what has happened when you realize that you have made a mess. that you have made a mistake. Apologize for what has happened. All you need to say is, I am very sorry for what has happened. I will do my best to remedy it. That is not an admission of liability, but I can tell you that a number of cases that I've litigated right through to the Supreme Court of Appeal have been instituted and have been pushed to their limit because the doctor refused to either to apologize or to play an active part in trying to remedy the situation. So please, if you can bring yourselves to apologize, I am sorry. I will do my best to remedy the situation. I'm sorry this has happened. You need say no more than that, but believe me, it will mollify an extraordinary number of patients to the extent that they might not bring a claim against you. I can name, as I've said from personal experience, scores of cases where the patient has decided to sue almost solely because of the doctor's offhand, uncaring, unhelpful, dismissive, and unapologetic approach. It costs nothing to apologize, but it could save you or your insurance provider a ton of money, stress, and grief. That then concludes my talk. I could go on for hours and hours, but I'm sure you need to call it a day. I hope you found it informative. A lot of what I've said is contained, as you can see from the background, wrong side, to my talk, the basic law for doctors, protecting patients, protecting practices. If the content helps you just once to avoid a malpractice suit, as it will have been a very worthwhile purchase. It's a small book, it's in paperback, it's very readable, it contains those vitals which are easy to absorb contents. And as I say, and I'll repeat again, it is available at the site LexisNexis, all one word, lowercase, .co.za /store, S-T-O-R-E. Type in the bar basic law for doctors, click on the book which then appears, and you will be able to order a copy. For your own sake, please buy a copy and please forward any questions. I would be very happy to answer them. Good evening to you all.
Thank you very much, John, for an incredibly informative webinar. I want you all to know that the picture that was just displayed probably is a bit of a misrepresentation. The book, if you can see it on the camera, looks like this, and it's that thick. It's not an encyclopedia or a tome. This is something that's very easy to read and is written in a style that I must tell you is very easy to read. So this is probably something that we should all be reading at some point of our career, irrespective of whether you've been fallen in a hole with respect to negligence or not. We have time for a handful of questions, and I stress a handful. I think everyone's tired, and I'm sure John is as well, coming to us all the way from Tampa in Florida. So like we did last week, William, who's the head of our legal department at SAMA, and myself will sort of tag team just to pose questions from the chat. We will not have the time to get through all of them. And as William said last week, we will attempt to deal with the ones that are posed that are not answered online, or get back to those doctors who've asked those questions. So I'm just quickly skimming through some of the questions, and I will ask the first one and William the second one, and we'll take it from there. The first question that comes to mind here is from Zifried Makoni. Is it fair to apply South African medical treatment guidelines to all healthcare facilities? This is very topical at the moment, especially with some of our public facilities literally not having the equipment the doctors need, irrespective of where they are located. Should the locality rule not apply? Should context not be taken into account and determine outcome of judgment? Perhaps if you can give us some tips on that, please, John. Thanks.
certainly it's a very relevant question in South Africa's socioeconomic circumstances. And again, if one goes back to the reasonable doctor in the case of public facilities, provincial hospitals, one goes to the question of the reasonable provincial hospital. And if on the evidence the court finds that a reasonable provincial hospital in the circumstances of the particular hospital in question did not have the facilities, and those facilities could not, because of socioeconomic circumstances, have been provided, then that hospital will not, or the professionals working in that hospital with those facilities will not be held to be negligent. It is as simple or as complicated as that. But the locality rule is a slightly different situation. The locality rule actually doesn't apply as far as, or the locality rule, strictly speaking, does not apply as far as the level of facilities are concerned. The locality rule used to apply. It does not apply in South African circumstances anymore as far as doctors are concerned. And there it used to apply that, for example, a practitioner who is practicing in a rural situation and has always practiced in a rural situation should not be held to the same standard as a GP who has had the same training, who is practicing in a modern, efficient hospital. The court in that situation, irrespective of the actual circumstances, applies the same standard of skill and care. That is not to say that the physical circumstances in those situations, for example, a doctor who is delivering a baby in a hut in rural circumstances with no electricity, no running water, and no other facilities, would not be held to the same standard as a doctor who is delivering a baby in a modern, efficient hospital. But there is a distinction to be made as far as provincial hospitals are concerned, or provincial healthcare facilities are concerned. As I've said, if a provincial healthcare facility does not have the facilities which it ought to have had, but those facilities could not be provided because the state simply could not afford to get them there for whatever reason, and those reasons are reasonable, then the court will take that into consideration in determining whether negligence should be applied.
Oh, thanks so much for that answer, John. Good evening, everyone. The next question, although it might seem like a simple question, there's more to it. This question comes from Dr. Faison. I hope I pronounced that correctly. So who decides what a reasonable doctor would have done in similar circumstances, John?
The answer to that is that the judge who is hearing the case decides that. And he or she decides that by hearing, as I said in my talk, from experts in the same field or experts who are qualified to comment on what that particular doctor should have done. Now, in any particular case, you're very likely going to get experts from both sides, and one expert is going to say one thing and another expert is going to say another thing. And very often they clash, although these might be the most eminent specialists in the particular field, they have different opinions. The judge then has to weigh up what is the situation that applies in that particular circumstance. And there is a set of procedures that the judge has to go through in considering that question. But ultimately, it is the judge that looks at the circumstances as informed by the expert evidence, and if necessary by the defendant doctor, as to what the circumstances were, what a person in that particular doctor's situation would have done. And the judge then weighs that up, and there are very clear guidelines as to how a judge must come to that conclusion. And going through that set of decision-making processes, the judge will then say, this is what a reasonable practitioner would have done. This is what the defendant did. The defendant did not come up to the standard which would have been expected of a reasonable practitioner in those circumstances. But ultimately, it is the judge in that particular case which decides.
Perfect. Thanks so much, John. And sorry, just related to that, I see there's quite a bit of concern amongst our attendees about what would be termed the hired gun expert. If you could maybe just comment on how that gets treated in the courts by the judge.
When you talk about the hired gun expert, you talk about the expert who's paid to give evidence in court. It's unfair to call them hired guns because, in fact, the expert, both the defendant doctor and the plaintiff, the injured patient, both have experts, and both of the experts on each side, and there might be a panel of experts on each side, all of them are paid, they are highly paid, and they are there to give their evidence for each side. The fact that they are paid in reality has no bearing, or in very few cases has any bearing on the evidence they give, because as you will see from my book on medical malpractice, the bigger one, the task of an expert in a medical negligence case, in fact, any expert, is to give a completely impartial and unbiased opinion, irrespective of which side he or she testifies for. And if the judge suspects that any expert is a hired gun and is therefore giving evidence that is either biased or not impartial, because they are testifying for one side or the other, that is usually a large factor in that evidence being excluded, and it will be excluded if any bias presents itself in the hearing of a case.
Thanks so much, John. I think that should give some of our attendees some assurance. Over to you, Mark.
Thank you very much, John. There have been a number of questions posed about social events and social circumstances. The one that keeps on coming up is what happens if a doctor happens to be out socially and has had a couple of drinks and a medical emergency arises. I know that the definition of an alcoholic is apparently someone who drinks more than their GP. So this might be quite topical. What happens in those kind of circumstances? And another specific example was given. What happens if you happen to be participating in an event? Let's take the Comrades Marathon as an example, and someone collapses. Knowing that these events have hired medics, is it good enough to call an ambulance, or should you be stopping and treating that person while you are there? Perhaps if you can give us a few ideas on these.
Sure. As far as the social event is concerned, I suppose it goes without saying, but maybe because of the definition of a drunk person that you gave, if you have had too many drinks and you feel that therefore your judgment or your medical expertise is impaired, you would be perfectly within your rights to step back and not come forward, because there you would be exercising sound judgment in not endangering the patient. But presume you just had a few drinks, but you were still therefore able to render assistance. If the criteria which I gave you for a true medical emergency are there, you would, I think, be obliged to step forward and render what assistance you could in the circumstances. And again, this is provided it is a real medical emergency. If it's just somebody puking and feeling nauseous because they've had too much to drink, then you would not necessarily be obliged to step forward and give them a panado or whatever it happens to be as far as their condition is concerned. It would be sufficient if they were told to lie down by the host or hostess. But if it is a real medical emergency, so for example, a heart attack, irrespective of your level of expertise, if you were able to render some assistance which might be of help in the circumstances, you would, I think, be obliged to come forward, provided all the criteria which I set out in my talk were fulfilled. As far as the Comrades Marathon is concerned, if you were participating in it and somebody in front of you collapsed and you happen to be a medical doctor, I think it would be incumbent on you to immediately render what assistance you could, even if it impaired your performance in the Comrades. But it would also be the correct thing to do to summon an ambulance or to summon a medic who was close by. If there's a medic close by, or if there's a paramedic close by, or an ambulance can be summoned within a reasonably short period of time, then you would be within your rights to simply carry on because the patient would be receiving the necessary care and attendance. So it's doing what is immediately required is what is important, provided you are able to render some sort of care which would be of help to the person who is in dire need.
Thanks so much, John. I just want to read this comment. I quite enjoyed it, from Martin Richardson. No doctor in court says, I wish I had written less. Thought that was quite funny. And then a question from Dr. Kutzer. If a patient-doctor relationship exists, are you obligated to answer calls of patients for assistance for emergency or semi-emergency situations 24/7 if there is an emergency room available?
That would obviously depend if there is an emergency room available, but the answer to that is yes, you would be, but it would be within your rights to ask, is there an emergency room available? How close is that emergency room and how contactable is the emergency room? In other words, is it available 24/7? If that is the case, and if the patient can be got without endangering his or her further condition to that emergency, then you would be within your rights to refer that patient to the emergency room. However, the underlying answer is that if you have a doctor-patient relationship and it is a genuine emergency, which you can ascertain over the phone, then yes, you would have to attend to that emergency. And that might mean going out to do so. I know, and particularly here in America, I don't think, as far as I'm aware, that doctors ever do that, although I can recall my father in the 50s, 60s, and 70s going out at 3 o'clock at night to Vereniging to answer what turned out not even to be a medical emergency, but doctors did that. I'm not sure in South Africa whether doctors do that anymore, but strictly speaking, legally, they would have to answer a call such as that if it was a patient with whom they had a doctor-patient relationship.
Perfect. No, thanks so much, John. And just from my side, thanks so much for doing this talk tonight. I think it was really insightful and our members really benefited from it. And with that, let me throw it back to Dr. Human to close.
Yeah, thank you very much, John. Much appreciated for all your expertise. I think you might have scared a lot of people with your last statement. Obviously, there has to be some degree of reality and perspective with social media tools like WhatsApp and a patient base of 20 or 30,000 people. It's practically just impossible to ever attend to all things, and sometimes your phone is off. I mean, presumably people sleep and they're not required to keep their phones on 24 hours a day, 7 days a week. What happens if you're away on holiday? So there must be some kind of extenuating circumstances.
Indeed.
So I guess the question then that arises is when is it not an extenuating circumstance? When is it your obligation to answer a call? I mean, obviously someone you haven't seen for 8 years, but once upon a time you had a patient relationship with, that's a very different case to someone who you operated on 24 hours ago and they went home, but now they've got an emergency. They're totally different scenarios. So is this a common sense thing, or how do we?
The question has a number of nuances. First of all, the question as to whether you have to be available 24/7. Is your phone, can you turn your phone off? Can you go to sleep? Can you be not contactable? Of course you can. And if a patient with whom you have a doctor-patient relationship can't get hold of you, that's not your fault. So you can turn your phone off, you can go to sleep, you can make yourself uncontactable. Of course, you mustn't make yourself uncontactable in the second situation where you've just operated on a patient. There is a possibility which a reasonable surgeon would foresee that an emergency might arise. Then you should not make yourself uncontactable. But in the situation where you had a relationship with a patient 8 years before, if the patient can't contact you for practical reasons, that's toughies, they must go to somebody else and you wouldn't be liable. If, however, they happen to get hold of you and there was a doctor-patient relationship and it is a genuine emergency, even if it's 3 o'clock in the morning and you happen to be silly enough to leave your phone on, then yes, you would be liable to go out, provided it is, of course, a genuine emergency, which you hopefully would be able to ascertain by asking the correct questions. So
Great, thank you very much.
The moral of the story is switch your phone off when you go to sleep or when you're out on the golf course.
Thank you very much, and thank you all to all the attendees. I hope this webinar series is proving beneficial. 2 take-home messages. Number 1, get basic law for doctors. Really, it is worth your time, worth your while to go through this book and read it. You will learn lots, and it will protect you. 2, we have our next webinar coming up next Thursday, and that is on criminal liability. And of course, that is a hornet's nest, especially in South Africa, with no varying degree of negligence, which goes quite far to the core of the problem. So hopefully we can provide you with some perspective on that. Thank you very much, everyone. Thank you, John, all the way from Tampa, Florida, and thank you very much for your time.
It's a
Good
pleasure.
evening, everyone.